Welcome to the third and final day of the Society of Construction Law India International Virtual Conference on Construction Law and Arbitration. I'm Raghav Mudgal, an advocate at Chambers of Senior Advocate Ratan K. Singh and a member of Board of Reporters at SCL India and your host for today. We surely have saved the best for the last as we have some exciting sessions scheduled for the day. Before we commence, a reminder for everyone who has not yet participated in the quiz, the Construction Law Trivia by Atkin Chambers, London, will end at 2 p.m. Indian Standard Time. To participate, you can enter the engagement room in the virtual lobby, where you can also take photos with the SCL India branding for your social media posts. We have an exhibition hall where you can find information about our sponsors and what they do. There's also a session room where you can catch up on any session that you may have missed or would like to watch again. Simultaneously, we also have a session going on in Auditorium 2 about use of mediation for resolving construction disputes, an exclusive by Madhyam, followed by a workshop on FIDIC contracts. So let's begin. Our first session is one of the most, if not the most, discussed and pondered upon topic of liquidated damages. This session is an exclusive brought to you by Masin. Masin provides expert engineering and construction claims analysis and expert testimony services to the engineering and construction industry worldwide. Its staff has extensive international experience on large and complex projects. Masin widely testifies as an independent expert in mediation and arbitration forums. Masin services clients through its offices across the globe, primarily in India, UAE, Qatar, Oman, Kuwait, Singapore, and Saudi Arabia. Each of these offices has a substantive strength of professionals, including partners and consultants with their own special area of expertise. For moderating this session, we have with us today Mr. Adrian Cole, an independent arbitrator. I welcome Mr. Adrian to kindly take over the session now.
Thank you, Raghav. Good morning, good afternoon, good evening to wherever you are. Thank you for joining our session. We've got an excellent panel for you today, and then a very interesting topic relating to liquidated damages and the question as to whether it is an enigma and whether it needs to be reconsidered in the context of the Indian context. Most of you, I hope a lot of you will be familiar with Section 74 of the Indian Contract Act. This provides for recovery of damages and liquidated damages in particular. I'll go into that more in a moment. And our session today is going to be looking at that provision in the context of India, but also from a civil law and a common law context. The common law from England in particular, and civil law from the Middle East with reference to the UAE in particular. We've got an excellent panel of speakers. Let me introduce those to you now. We have Rohit Singhal, who is from Masin, who's an expert in quantum and delay. Rohit, good morning to you. We have David Savage, who is a partner. Thank you. Good morning. We have David Savage, who is a partner at Charles Russell Speechlys in England. Good morning, David.
Good morning, Adrian. Great to be able to join you.
David is calling from a cold and wet England, and it's a very unearthly hour there at the moment. So well done for joining us. We also have Arun Visweswaran. I hope I pronounced his surname properly. Good morning, Arun, who's based currently in Dubai and therefore is going to address us on the process in the Middle East. And we also have Gopal Jain. Good morning, Gopal, who is a senior advocate in the Supreme Court of India. Good morning.
Good morning.
Without much ado, let's get going. Section 74 of the Indian Contract Act. Let me just read that out so that everyone is familiar with it. and it provides that when a contract has been broken, if a sum is named in the contract as the amount to be paid in case of such breach, or if a contract contains any other stipulation by way of penalty, the party complaining of the breach is entitled, whether or not actual damage or loss is proved to have been caused, to receive from a party who has broken the contract reasonable compensation. And that compensation is not exceeding the amount so named in the contract, or as the case may be, the penalty stipulated. That's quite a mouthful. So let me just break that down into some component parts, if I may. First of all, there needs to be a contract which has been broken. There needs to be a sum which is named, or some other stipulated mechanism. There needs to be whether or not actual damage has been lost or incurred. There needs to be a provision for reasonable compensation, and compensation should not exceed the amount named or the penalty stipulated for. So let's get going with the Indian position first of all, and let's turn to Gopal Jain. Gopal is, as I've already mentioned, a senior advocate in the Indian court. He is has 25 years or more, wouldn't believe it from looking at you, Gopal, of experience in arbitration and commercial litigation. You've represented Indian and multinational clients in complex and contentious construction matters, and your practice areas include commercial arbitration, infrastructure policy, and regulatory disputes. And you've provided me with a list of stellar clients, which I won't read out, but they include entities such as the National High Speed Rail Corporation, central government, and state corporations. So without further ado, Gopal, let's hear your perspective on liquidated damages from India.
Yeah, thank you, Masin, and thank you, Adrian, for the introduction. If I was to just turn myself around, you'll know it's more than 25 years experience because of the loss at the back. May I just start by saying that liquidated damages is, as the subject says, an enigma, a conundrum, unruly horse. And perhaps that's the reason why we're all here together, because there are so many different shapes that it takes. In the Indian context, by and large, when you use this word, it is really evocative of a pain point or a bugbear. So it's not a clause which sits easily on anyone, and there's always a sense of fear as to how it will be applied and triggered, sometimes, as we say, almost like a clause in terrorism. One of the main reasons in the Indian context is you have Section 74 of the Contract Act, as you indicated, pre-colonial, so it has stood the test of time. You have Indian case law, which is constantly evolving, so judge-made law. And then you have contracts, and by and large, we find that contracts entered into with public sector undertakings or government corporations have very different kinds of clauses. So all of this makes it a delight for lawyers and creates a huge amount of uncertainty as far as business is concerned, because you can never put your finger as to what kind of outcome you'll get. It constantly, as I said, evolves and changes. The next point that I'd like to make is that when we look at these clauses, we sometimes look at them in isolation. But one of the cardinal principles of interpretation is really to see this in context holistically and to see it in the context of the whole contract read as a whole, because you really have to look at what the parties intended, which is why principles such as principles of business efficacy have been evolved over a period of time, now used in India as well, to say that please produce the outcome which the parties intended And therefore, a sense of more holistic and balanced interpretation is also something which is important and which the Indian courts have applied. About 3 years back, the Supreme Court of India gave a judgment which basically identified how to interpret commercial contracts. And since this has to be done with some commercial sense, and that's very important because instead of pure black and white form of interpretation, it's very important to gauge that commercial sense which the parties intended, because in a commercial transaction, that is of paramount importance. So these are some of the principles or the framework in which we should look at this subject. Moving on, Indian law from Fateh Chand, Maula Bakhsh, ONGC, Kailash Nath, every decade or so undergoes changes. Many of these cases actually did not in the contract use the word liquidated damages. Perhaps it was only in ONGC, there were forfeiture clauses, etc. But principles of interpretations have emanated from there. And in 2015-16, when the Kailash Nath judgment came, the court in fairly categoric terms said, look, whatever it is, even if there is a stipulated amount in a contract, as you broke down 74, but a sense of legal injury is important. Some actual loss has to be caused, and you can't just trigger it and use it. And I think this is very important because it provides a sense of balance to the whole thing, because many times this provision was invoked more like a tool of oppression, which came to be simply because there was such a provision within the four corners of the contract. So achieving commercial equilibrium and a sense of balance between rights of an employer and a contractor is important. And Indian courts are famous for evolving principles such as contextual interpretation, give it a purposive meaning, and I said of late, even giving it commercial meaning and sense. So this is the overall context in which we have to see the setting of this particular provision. But net at the end of the day, the nature of the contract, the kind of transaction becomes important. This is really a very fact-driven, fact-intensive exercise. So that's an important aspect. A careful assessment, therefore, has to be made on a case-to-case basis. This becomes very important. And yet it remains that these clauses have been negotiated and are part of a contract. And therefore, there's a clear contractual stipulation. But the manner of its application, how it's to be triggered, is something which, as I said, the evolving case law in India has kind of gone from Maula Bakhsh, Fateh Chand to Kailash Nath of recent vintage. And now several high courts have also applied this yardstick. So this is broadly, as an opening, what the Indian position on the subject is. Back to you, Adrian.
Thank you very much, Gopal. That was an excellent introduction. Let's move on to another area then, which is the perspective from England. And we have David Savage, as I mentioned, as a partner at Charles Russell, Speechlys. David is a leading international and UK construction lawyer. He co-heads the construction infrastructure sector at Charles Russell Speechlys, and he's qualified both as a solicitor and as a barrister, and acts for all parties in the construction process. And he's recently been very busy in the Middle East, having been involved with the Bahrain International Airport, and he delivers training on FIDIC and ICME contracts throughout the Middle East. And David has an extensive following on social media. So David, as an influencer, to tell us your perspective from English law on liquidated damages.
Well, thank you very much, Adrian, and it's great to be with you all this morning, and a really fascinating topic. Let's just step back and just remind ourselves, why we have liquidated damages provisions in construction, engineering and infrastructure contracts generally, because I think the sort of the policy economic background to LDs is then highly relevant to whatever has happened around the law of liquidated damages, whether that be in a common law jurisdiction like the one that obviously I practice in domestically, or indeed civil law jurisdictions or jurisdictions like in India, where the common law position is modified by statutory intervention or creative tension, shall we say. In this case, obviously, the provision section 74 of the Indian Contract Act. So we have liquidated damages, I think, for 4 fundamental reasons. The first, of course, is one that benefits both parties, which is the fact that liquidated damages do, or at least should, bring an element of certainty to both parties in relation to the types of breach for which liquidated damages have been specified. And in our context, that's obviously typically time, but it's also sometimes technical performance of a building or of plant or machinery in sort of specified performance terms. So that's the first reason we have it, to try and give certainty to both parties. The second reason that we have LADs is to limit a contractor's liability so that they know the price of breach. And again, that's particularly relevant in the context of delay damages. All of that ought to achieve the third objective, which is saving time and expense, particularly when there is a dispute. And classically, that's around time, because we all know that time is money, and we all know that time is heavily contested in construction, engineering, and infrastructure projects terms. And the fourth and final reason, policy reason, that we have LADs is that they act as a deterrent to breach. So that's really about the level at which they're set. We've talked about how liquidated damages obviously provide the price of breach, but if they're set at a meaningful level, let's say, they ought to act as a deterrent to that breach. And then there are some sort of subtleties to the position. So, for example, normally in a general damages context under English law, you are obviously under a duty to establish breach, causation, and loss in that classic sort of formulation. But you're also required to act in a way which mitigates your loss as the party suffering a breach. And of course, if you have chosen to liquidate damages for a particular head of loss, that duty of mitigation is no longer relevant, because you now know the price of that breach. And subject to what I say in a moment about genuine pre-estimate of loss and all the case law around that, you can specify a level of liquidated damages which might be, or might prove to be, higher than what your fully mitigated losses actually might have been had you been in a situation where you had to establish general damages and prove your loss. So there are these quite significant policy or economic underpinnings for the use of LADs generally in the construction, engineering, and infrastructure sectors. And I think that's a really important sort of starting point when we then look at the creative tension with the underlying case law, statutory provisions such as in India, and civil law code provisions such as the ones we're going to hear about from Arun in the Gulf states and the Middle East, and indeed in many other jurisdictions. So what's been going on around the law of liquidated damages in English law? Just a couple of comments about that before we then travel to the Middle East and see how this topic is dealt with there. Well, I would say for nearly 100 years, the focus and the formulation of the debate has been this phrase, genuine pre-estimate of loss as against being a penalty. and many people know and identify with that phrase in the context of the case law position, certainly under English case law, common law, so far as assessing and enforcing liquidated damages provisions. And that expression comes from Lord Dunedin's judgment in the Dunlop case, which goes back to 1915. And for much of the 20th century, therefore, practitioners tended to assume that that was the fundamental test for whether liquidated damages provisions could be enforced. It depended on whether the rate specified was, quote, a genuine pre-estimate of the loss. And what I would say, in interesting timing, a case came along that went to our Supreme Court, what was formerly House of Lords level judgment, so the highest court in the land. A case came along that was heard in 2015. McDessie and Cavendish Square Holdings is the name of the case. And really, I think, quite significantly restated the position around liquidated damages and moved the debate on from simply a focus on Lord Dunedin's genuine pre-estimate of loss versus penalty point. And it's relevant to just sort of explain what space has now been opened up under English common law around the enforcement of liquidated damages from that reconsideration of this whole area by the highest court in the land. So just briefly, Lord Dunedin's sort of four-part test for enforcing LADs was all about, well, point one was a sum would be a penalty if it was an extravagant and unconscionable figure compared to the greatest loss that would have resulted from the breach. Where a breach was a failure to pay a sum of money that was less than the sum stipulated in the LADs, the stipulated sum was likely to be viewed as a penalty. The third point was that if a single sum was specified for multiple different types of breach, that gave rise to a presumption, but no more, that that sum would be considered as a penalty. And of course, in our English context, penalty is bad because it means that the LAD's provision is not enforceable. And the fourth point from Lord Dunedin was that a sum was not a penalty simply because an accurate pre-estimate of the likely loss was almost impossible. And one can have some sympathy with that point, because in some ways that's why you want to liquidate damages in the first place, to deal with that difficulty. So what consideration did the classical position receive in that McDessie case? And one of the interesting features of liquidated damages cases for the construction, engineering and infrastructure sectors is that some of the leading authorities, certainly in the UK, around liquidated damages come from other sectors. So this McDessie case was actually about parking fines, amongst other things. It wasn't a construction case. And the case that's gone up to the Supreme Court more recently in the UK this year, in 2021, was about liquidated damages in a software contract. And again, this is kind of interesting and relevant because some of the sort of heavy lifting in case law development terms in English law has been done by cases that are not from our sectors, even though, of course, probably the greatest use of liquidated damages provisions, or the greatest systemic use of liquidated damages provisions, particularly, as I say, around compensation for delay, obviously is in our sectors of construction, engineering and infrastructure. So that's also an interesting feature. But just briefly about McDessie, because this is the sort of 100-year-on review point for what was previously the position here for a long time. The Supreme Court, well, I'll give you a quote from one of the judgments, which will give you a flavour of where they were coming from here. So this is straight from the judgment. Lord Dunedin's speech in Dunlop achieved the status of quasi-statutory code in the subsequent case law. some of the many decisions on the validity of damages clauses are little more than a detailed exegesis or application of his 4 tests, with a view to discovering whether the clause in issue can be brought within one or more of them. In our view, this is unfortunate. In the first place, Lord Dunedin proposed his 4 tests not as rules, but as considerations which might prove helpful or even conclusive if applicable to the case law under consideration. He did not suggest they were applicable to every case in which the law of penalties was engaged. So I started off my comments by saying, in England, in our common law, we didn't have statutory intervention or civil code positions that created a creative tension with the case law position. And here's the House of Lords, or the Supreme Court, as it was by 2015, saying that, in a sense, a case had almost adopted a quasi statutory sort of level of interpretation and needed to be revisited. And that's what the Makdessi case did. And in sort of summary level terms, what Makdessi opened up was more space to look at commercial purpose around LADs and to look at the legitimate expectation of LADs representing and implementing, if you like, the deterrent side of the equation when it came to LADs. So that was the space that was opened up. And now when we advise clients, we go well beyond simply looking at the case law around what constitutes a genuine pre-estimate of loss as opposed to a penalty. And we look at these wider policy considerations reflected in that House of Lords decision. The final point I want to make before handing back and traveling to the Middle East is that we've also had a very interesting case go up to the Supreme Court this year. It's called Triple Point. And that case was all about what happens when a construction contract is terminated. Do liquidated damages survive termination and continue to accrue post-termination when you have to bring in another contractor to complete somebody else's work? And that case in the Court of Appeal had opened up that possibility that liquidated damages might continue to apply post-contractor termination. And that was, let's say, an unconventional finding compared to the first instance finding in the Technology and Construction Court. And when it went up to the Supreme Court on appeal, the conventional position under English common law was restored, which is to say that liquidated damages will only apply under a construction contract until the point at which that contract is terminated, and any losses that an employer might suffer post a contractor's termination would need to be proved in general damages to the extent that those losses occur after the point of termination. So conventional English common law was restored in that Supreme Court decision earlier this year. So there's been a lot of discussion around this Triple Point case. But with that, I'm going to hand back to Adrian.
Thank you, David. Certainly some very interesting developments taking place in England, and it sort of marries with what Gopal has been telling us about India in terms of the law is never standing still and it's continually changing to ensure that it reflects commercial necessity. Let's see what the position here is in the Middle East, and I'm pleased to introduce Arun Visweswaran. Arun is a partner in, a senior associate in Clifford Chance in Dubai. He's also a qualified engineer, and he's been based in Dubai since 2012, so there's plenty of experience of how things operate in the Middle East, having previously operated from London and Singapore. Arun specializes in commercial arbitration, including construction and project disputes, and also leads or co-leads Clifford Chance's technology practice in the Middle East. He's conducted advocacy before the DIOC Court of Appeal and is licensed to appear before the DIFC courts, and has edited the commentary on the DIFC Law of Obligations published by LexisNexis, and also editor of a guide to company directors, a practitioner's text on Indian law by LexisNexis. So without further ado, with some excellent qualifications, Arun, please let us know what the position is from your perspective in the Middle East.
Thank you very much, Adrian. Before I start, can I just check you can hear me clearly?
Yes, we can.
Yep. Okay. Thank you, everybody, to SEL, to Masin, for the very kind invitation to speak at today's SEL conference on LDs. I've been here for a while, and having originally trained from a common law background, it's been quite an interesting juxtaposition to see how the position differs in the Middle East and in civil law jurisdictions. For those of you, I appreciate many of you might be fully aware of how civil law jurisdictions operate, but for those who are relatively new to the civil law jurisdictions, I thought I'll give a very brief whistle-stop tour of the history. So a lot of the civil law jurisdictions, the law stems from what we call the Napoleonic Code, which is obviously from the time of Napoleon. And in that particular code, penalties were generally permitted to encourage performance of contracts. So it wasn't, unlike the common law jurisdictions, it wasn't something that was necessarily unlawful. Over time, that position has modified itself, it's changed. And I think the current position can be fundamentally summarized as being significantly different from what David and Mr. Gopal Jain have just indicated to be the position in India and England, which is the common law position. So the common law position tends to be that parties' contractual agreements are generally upheld, and therefore courts and tribunals are generally hesitant to try and modify the bargain. However, in the Middle East, in the civil law jurisdictions, and not just UAE, but the neighboring countries, while LDs are technically enforceable under the law, they are not, the amount of LDs is not etched in stone. And what I mean by that is it is always open to a party to argue that the amount is not commensurate to the actual loss suffered by the other party. And this, having read the background to Article 74 and having heard Mr. Jain speak about some of the case law, I think the position is somewhat similar to the pre-saw pipes decision or line of decisions in India, where actual loss still requires to be proven in order to benefit from LDs. However, I think the fundamental difference between Indian law and the Middle East or civil law jurisdictions is the burden of proof. So, for example, in Indian law, it's the party that relies on LDs that needs to demonstrate actual laws. Whereas in the UAE, Egypt, Saudi, etc., it's the party that's trying to resist LDs that needs to prove that the LDs is not equal to the actual loss suffered. So it's quite a reversal of burden of proof there. Now, having said that in very high level terms, that's kind of the whistle stop tour of how this jurisdiction has evolved. I thought I'll give a bit more background into UAE, which is the region I practice in, and whose laws are not completely dissimilar to some of the laws you'll find in the Middle East generally. Now, again, in a slight difference from common law, the civil law system tends to codify most of its laws. So most of its laws are in statute. And case law, while it helps interpret some of the statute, it tends to apply the law as is, and it's not necessarily always the source of new law. In the UAE, the most relevant for our purposes today is what we call the civil law, or civil code, sorry, which is the UAE Civil Code Law 5 of 1985. Another aspect which is prevalent in what we call the onshore UAE court system is there's no generally prevalent system of court reporting of precedents. What I mean is binding precedent, which is different from some of the common law jurisdictions. Now, the case reporting, there have been some developments of late. So the highest court decisions, you do get made available online, but definitely the lower courts' decisions are still not always publicly available. And the proceedings tend to be in Arabic, and even the laws, the statutes are in Arabic, which is the superseding version. But most of us common law lawyers, or even civil law lawyers who are not necessarily Arabic speaking lawyers, we tend to work with translations, and we often work with UAE national lawyers when we represent clients before these courts. So we do have a lot of experience using that method of working, particularly when it comes to the issue of LDs. So that in terms of the premise, UAE Civil Code does recognize the freedom of contract. So it's Article 257 of the Civil Code, which allows the recognition of what the contractual parties have agreed. The only exception is where the mandatory provisions of law, which require some sort of digression from what the contract stipulates, in which case the mandatory provision takes effect or supersedes. When it comes to LDs in the UAE, the key provision is Article 390 of the Civil Code, and it has two limbs. And I won't elaborate or read it out verbatim. But in a nutshell, the first limb essentially allows or recognizes that parties are free to fix the amount of compensation in advance, i.e., an LDs clause. It's in line with the freedom of contract principle, which I just mentioned. So, in theory and in practice as well, LDs are allowed under UAE law. But it's the second limb of Article 390 that is the key point for lawyers and clients in this region, and is not uncommon to many of the other civil law statutes you'll find in this region. So, in the UAE, the judge or the tribunal has the power to either increase or decrease the amount of stipulated damages to be commensurate with the actual loss. So, as I mentioned previously, the burden of proof is on the party resisting LDs, and it's not an automatic power. So, it's not that the judge or the tribunal would just apply it of their own volition. A party has to raise it in argument, but obviously, it's not the most difficult argument to raise. So, in my experience, parties try and tend to raise this argument, particularly if you do have credible proof that the loss suffered is much lower. Now, as I said, it's a mandatory provision, so you can't contract out of it. So, if a contractor, for example, raises this argument when an employer claims for LDs, a judge or tribunal would have to treat that argument on its merit and consider it fully, even if the contract tried, for example, to opt out of Article 390. And as I mentioned earlier, this particular provision allows the judge or the tribunal to increase or decrease LDs. In my experience, it's usually the decreasing aspect that has succeeded in the past. And for example, I'm aware of one case. It's not the most sexy of cases, if I may put it that way, but there was a cafe owner, and he had ordered around 40 billiards or snooker tables. There was a delay LDs clause, and there was a delay by 2 months in delivering those tables. And he applied for the full amount of LDs, which had been hit by that time. But the court reduced the LDs because during the expert process in the UAE courts, the claimant admitted that their loss of revenue was actually much lower than the LDs amount. So the court reduced the LDs to the actual loss that was admitted by the claimant. But in theory, it could also apply the other way. So you could, if you're an employer, for example, who has suffered damages higher than the LD's cap, you might try and argue that the judge should increase the amount of LDs. But as far as I'm aware, that type of increase does not occur easily. And as far as I'm aware, it hasn't actually occurred in the past. Again, it's similar to the Indian context in some instances, because it's not always easy for the contractor to establish that LDs does not equal actual loss of the employer. It's not the easiest of exercises, be it for a lawyer or an expert, but nonetheless, it does provide an avenue for a party resisting LDs to try and vary the number, or indeed a party trying to increase LDs to rely on it. The other interesting aspect, again, which is not uncommon in civil law jurisdictions, is different to the English law position, which David just elucidated, which is there is no clear distinction that's made between penalties and LDs. The two are almost used interchangeably particularly when you read the onshore UAE code judgments. Often the word penalty is used, and so there isn't a particular distinction in that respect. And given, I mean, you could argue that the second limb of Article 390, which I just mentioned or described, works to essentially avoid penalty clauses because a judge could essentially lower your damages to what is the actual loss. So you could argue that that in effect prevents penalty clauses, but by way of pure nomenclature, courts tend to not distinguish them very clearly out here. One further point, or rather two last points I just want to mention is in the onshore UAE codes, I mentioned earlier in the billiards table case, the appointment of an expert. So that is a very common aspect of the onshore UAE code process, which is you will often get from the first instance onwards an court-appointed expert to prepare a report to hear out each party and prepare a report and submit it to the court. Now, while the report is not particularly binding on the judge in the UAE court, in my experience, it tends to be quite persuasive and is a process that is, I mean, it can vary, and for the more complicated disputes, it might not necessarily be the most prudent way of dealing with it, particularly if the expert is not an expert in that type of dispute. But for construction disputes, I think that there are quite a few experts who tend to deal with this before the UAE court. So you can get specialist experts for that. And last point, and I didn't want to elaborate on this too much because it covers some of what David has just explained, which is there are two free zones in the UAE, which are the Dubai International Financial Center in Dubai, which is otherwise known as DIFC, and the Abu Dhabi Global Market, which is another similar financial free zone in Abu Dhabi. I operate to a large extent in these two free zones, and our firm does the same, as do most of the international firms. The two free zones have their own set of commercial and civil laws, which are to a large extent modeled on English law principles or common law principles. And so, and they have their own court systems as well, which deal with cases before them. The DIFC courts, for example, has a specialist technology and construction division, which was instituted a few years ago. And I didn't mean to get into that too much because to a large extent, the principles that have been explained by David would also be the similar principles applied before these courts, which is because it is modeled and English law is very persuasive before these two sets of forums. So on that note, I appreciate it's a fair whistle-stop tour, and I know we're going to discuss some of the specific points in a bit more detail in due course. So I'll pass it back to Adrian to move the discussion forward.
Yeah, Arun, thank you very much. That's a very interesting discussion about what's happening in the UAE and the Middle East generally. Certainly, it's an ever-changing jurisdiction, as many people who follow developments in the Middle East will be aware. Let's move forward. Just before we do, let me sort of flag up to our audience. We have allocated some time for questions and answers to this session. If anybody has any questions they would like answered, please put them in the chat section, in the chat box, and when we get to that time allocated for it, we'll do our best to see if we can answer the questions relating to liquidated damages. Let's move forward now, changing the perspective from a geographical perspective to a specialism perspective. And we have Rohit Singhal. Rohit is the founder and CEO of Masin. And Masin's, as you'll know, is a leading construction arbitration expert firm. It has a global presence operating from 8 offices. Masin is a distinguished expert. He's over 25 years in international consulting. He's been appointed expert, whether in court or in arbitrations, in over 50 cases on delay, technical valuation, and quantum matters. And in 2019, he was awarded the prestigious Outstanding Expert of the Year award by international arbitrators and experts in engineering sector in the UAE. So from a man with such experience, Rohit, please tell us what your perspective is on liquidated damages from the perspective of an expert.
Thank you, Adrian. Good morning, good afternoon, good evening to everyone. It's a bright Sunday morning in New Delhi, from where I am located, from where I'm speaking from. Unlike London, where David might be seeing a pretty frosty weather. So the topic which we have been discussing about liquidated damages, you have heard the legal part of it from a English law perspective, Indian law, and Middle Eastern law. Now, let me give you some views from an expert perspective. I have a fairly decent experience of handling construction disputes in India, where what I have seen quite generally is that the employers tend to, at the drop of a pen, levy liquidated damages, and they do not get into the assessment whether the delay has been really caused by the contractor or is it something which is attributable to the employer. Honestly, liquidated damages is a pain point for both the parties who are managing a construction, who are part of the construction contract, be it the contractor, be it the employer. And a levy of the liquidated damages means that the project is delayed, and neither as a project head of, from an employer's perspective, if you are a project head of an employer's company executing a project, you would not be put yourself into a situation where you go to your shareholders and say that, look, my project is delayed, but I am charging liquidated damages. So therefore, that is also not good from an employer's perspective. Same way, if you are a contractor, you would not like that in a contract wherein nowadays the construction contracts have very stressed margins, that you would like to have 10%, which is typically the percentage of liquidated damages being levied onto you. So it's not good for both the parties. And from an expert perspective, LDs, which are generally levied in the event a project is delayed, or probably there are, as David said, performance LDs. But let me talk about the delay LDs, which are quite common in construction contracts. Now, if an employer or an engineer intends to levy a liquidated damages on the contractor, or a contractor intends to levy liquidated damages on the subcontractor, the first and foremost thing is that the attributability of the delay has to be undertaken, whether really the party on which LDs are going to be levied has delayed the project or not. And a lot of times, my experience, especially in India, is that the employers are not getting into evaluation and assessment of the extension of time submissions or delay notifications which have been submitted by the contractor, and they tend to levy liquidated damages. Also, my experience in India is that a lot of times contractors are generally just writing letters alleging delays caused by the employers without properly analyzing how much is the extent of the delays, which means coming to the point of delay analysis. Now, my piece of advice, and to all the people who are involved, stakeholders in the construction contract, is before you get into the zone of levying liquidated damages or arguing about that LD entitlement is not there for the employer, a delay analysis is very important to analyze and assess that who has caused the delay, whether it is the contractor or whether it is the employer. Because tomorrow, if this matter goes into arbitration and LD has already been levied or deducted, definitely there is an impact on the project. There is a levying of LD on the contractor, which means that the cash flow of the contractor is going to be affected. Money is going to be deducted or retained from the invoices of the contractor. So therefore, it is important that a delay analysis is undertaken by the employer and the engineer before assessing whether LD is levied or whether the contractor is liable for LD or not. And on the same point, a contractor, in case he intends to defend his position, should rather having the burden of proof to prove that the delay is not caused by the contractor, should analyze and undertake a delay analysis, quantify what is the extent of delay caused by the employer, and then go and seek an extension of time. A delay analysis is mandatory because not every delay by an employer or every delay by a contractor causes a critical delay. It does not mean that the end date of the project is going to get changed just because there is a delay in the project caused by the employer or vice versa by the contractor. You have to have critical delays to lead to a change in the end date, which means that only if the end date is getting affected and contractor is entitled for extension of time, or an employer is entitled to liquidated damages or additional extension of time. So the first and foremost thing is that before you get into the zone of LD, both the parties should get on to do a delay analysis to find out who is responsible for the delay. Now, the second thing is, as Mr. Jain and Arun has pointed out, unlike English law in both Middle East and India, the actual loss has to be proven. Now, what are my experience, especially in India, is that employers generally are not maintaining those requisite documents, wherein as a quantum expert, I can analyze and assess what is the actual loss which has been caused because of the alleged delay caused by the contractor. What I have seen recently, as recent as just a few weeks back, wherein I was appearing on behalf of one of the employers in a very big mega power project. There were statements which were being made that the power loss was there, we could not generate the power. But the fact of the matter was that even if the contractor would have been able to finish his job, commission his part of the work, but the balance portion of the work was not done, which was basically the responsibility of some other contractor. So therefore, whether actual loss has been suffered by that employer who owns the power plant is a question mark. Was it because of the delay caused by this contractor, or was it because the other interface contractor was responsible, and as a result of which, even if this contractor on whom the liquidated damages were being levied was liable for liquidated damages, was responsible for delaying the overall commissioning of the project. So therefore, that actual loss related to that contract in question has to be seen, which means it could be a loss related to maybe additional money which is related to additional people which are deployed to supervise the project, or additional time expanded by the engineer and the supervising authorities from the employer side, or it could be some other loss which could be a loss which is directly attributable to the actions or delays by the contractor. So record keeping related to those quantification and valuation of the losses is very, very important when an employer intends to levy LD, because generally you would always see in Indian context especially, a contractor will definitely come out with an argument that since there is no actual loss, therefore the employer is not entitled to levy liquidated damages, while the employer on the other hand generally says that the contract allows me to levy LD. So that position is still a little bit shaky and a little bit unclear. As Mr. Gopal said, you have got the saw pipes, you have got the other DDA case wherein things are slightly not very clear. So two things which I would recommend from an expert perspective is, please do not just close your eyes and go and levy liquidated damages. Analyze, assess whether a contractor is liable for liquidated damages. And same way, I would say for the contractors also, when they have a contract, when they have a subcontract, and in case LDs are being levied on the subcontractor, an analysis, which is delay analysis, should be undertaken to see what is the extent of the delay, whether even LD has to be levied on the subcontractor or the main contractor. And the second thing which I would recommend from an expert perspective is that in case you are intending to levy LD, you should understand that what is the actual loss which is there. You should have records to prove the actual loss. Seldom I have seen that the employers are keeping such records, and it's more of a global arguments which are being put by the employer rather than getting into the intricate details of the documents to prove their actual loss. So I think, Adrian, that's what is my perspective from an expert point of view. Over to you. Thank you.
Rohit, thank you very much. It's very interesting. As an arbitrator, dealing with experts on a daily basis, it's always interesting to learn of the perspectives that they bring to the case and the light they can throw upon important areas. And I think you've touched upon a number of those. So thank you for that. We've heard from an expert's perspective, now about an arbitrator's perspective. I won't take very long on this, not least because I don't wish to give away all my secrets. But just to introduce myself, if I may, I'm an independent arbitrator, mediator, and dispute board member. I used to lead the disputes practice at King & Spalding, which is a leading international firm with a stellar reputation in arbitration cases. Having worked in that environment, I've been exposed to some absolutely fantastic cases and challenging cases, and that helpfully informs my understanding of how the industry works. But like Arun, I qualified in engineering at the start of my career. I then went on to practice as a quantity surveyor for a while before seeing the light and becoming a lawyer. And I'm privileged to be ranked by the leading directories, chambers and Legal 500 as a top tier, and also ranked as one of the top 25 construction lawyers in the world by Who's Who Legal. So that's sort of my background. But moving on to how this is relevant to liquidated damages, from an arbitrator's perspective, it's important to remember that what we're dealing with is a contractual issue. There must be a contract for there to be liquidated damages, and because that liquidated damages is a creature of contract, although we have Section 74 of the Indian Contract Act, which permits it to happen, and various other legislations and case law around the world. Without a clear contract, there is no right to liquidated damages. And secondly, it's essential that there is the necessary mechanisms within the contract to allow it to work. Without those mechanisms, there is no means to determine the application of the damages which are being claimed. So, for example, if there is no clear completion date in the contract or no way of determining that, then straight away one of the essential ingredients will fall away. Now, likewise, there needs to be a mechanism for determining the value. Sometimes the value is determined as a percentage of the contract price. That in itself can give rise to numerous issues, because we've heard that liquidated damages are intended to be compensatory, and they are intended to reflect a genuine pre-estimate of loss, and not to be contrary to sort of commercial necessities, as referred to by David in the McDessie case. But if they're not clear as to how they're going to operate, then that they are likely to fail and fall away. And percentages, for example, can be challenged on the basis that if it is intended to be a genuine pre-estimate, how can you then say, oh, it should be a certain percentage of the contract value, when that contract value may change for reasons for which the paying party, the contractor, has no responsibility. So if, for example, the contract price increases due to variations, that would increase as well the exposure to liquidated damages. And therefore, in that circumstance, the contractor's exposure has been increased for no fault of its own. And therefore, one has to ask the question as to whether that is fair, and whether then it is compensatory or not. We focus mainly on delay damages, but it is also worth pointing out, as indeed we've touched upon briefly, that liquidated damages can also apply to other components of the construction and engineering process. These include performance damages. So, for example, the contract may stipulate the output performance of the plant that is being constructed, for example, a process plant, a power station, let's say. And if the plant doesn't operate in the way that it is intended, as the contract should stipulate, then there may be damages payable for that in terms of the lower rates of production. One area that I see quite regularly is damages relating to other aspects of performance. So damages being imposed for failure, for example, to comply with health and safety requirements. Or in the Middle East in particular, we have requirements that from each country that nationals of that country should be employed. So in Saudi Arabia, we have the Saudiization process, or in the UAE, we have the Emiratization process. And sometimes one sees requirements that a certain amount of nationals should be employed by a contractor, and in the event they do not employ sufficient numbers, then they can be levied with liquidated damages. Now, in the Middle East, as Arun has already pointed out, the notion of penalty isn't taboo, as it may well be in India and in England, but it still needs to be compensatory, and therefore questions can arise as to whether those mechanisms, those clauses, fall foul of those legal principles. Another component that one sees as an arbitrator relates to legal representation. I've been practicing in the Middle East for 15 years now. So although I'm common law trained, I've been practicing civil law and common law here in the Gulf for a good time now. And it's always interesting working with civil law practitioners or sitting on a tribunal with civil law practitioners, because it always challenges one's perspective on the law and brings in different components to take into account. One of the strange components, of course, is that construction is made up of many parties, international parties, and their legal representatives are no exception. And it's not unusual in the Middle East, as indeed elsewhere, for the legal representatives to be of the same nationality or legal tradition as a party may be. And therefore, if you have two parties which are from common law jurisdictions, for example, you may well have legal representation which is from two common law backgrounds. You may well end up with a tribunal which is made up of common law practitioners, be they Indians or Australians or English or whatever. And that tribunal has to ensure that despite the representation from the parties, that if the law that's being applied is a civil law, that the tribunal complies with that. So one has to be careful about the submissions that can be made to a tribunal to ensure that the case is determined in accordance with the law that the parties have chosen, so that the resulting arbitration award has the best chances of being enforced and of being effective. We've touched upon, or David mentioned briefly about the benefits of liquidated damages from the point of view that it can introduce certainty and save time and cost. And I'd just like to dwell upon that just for a moment, which is that without liquidated damages, then the life of an arbitrator potentially can become much harder, and the arbitration case can become much longer and more expensive. And that's simply because without liquidated damages, it will be necessary for the parties to prove or disprove each element of actual damage. So liquidated damages avoids the need to look at and assess actual loss. But without it, then it is necessary to consider whether each and every aspect of the claim has been proven. And that will come down to looking at invoices and sums paid for each and every head of cost. And one can imagine in a construction setting that can be a pretty enormous undertaking. Parties already complain about how extensive and time-consuming issues such as disclosure or discovery can be. Without liquidated damages, those situations can expand enormously. So liquidated damages have a real benefit to the dispute resolution process. But it must be borne in mind that if liquidated damages were to fail, parties may not necessarily recover all of their general damages. And one of the reasons for this is that many construction contracts provide provisions which say that there shall be limitations or on recovery of consequential losses, including or exclusions of consequential losses. And those losses, for example, would include the sort of damages which a party would seek to recover as general damages. So, for example, if someone is building a housing estate and those houses are to be sold or let after completion has taken place, then if completion is delayed, then the developer is not going to be receiving his rental or his sale proceeds when he expects to. But he may well find that the contract as drafted does not allow him to recover those general damages because the losses he's seeking to recover may well be excluded because they constitute consequential loss by way of loss of income or loss of profits or other such descriptions. So it's important that parties be very careful when they're drafting their contracts to consider how these issues may work out should there be a failure. So that's my quick run through from an arbitrator's perspective. There are, of course, many things to be talked about, and one could do this for many hours. Unfortunately, we don't have that time, but we do have some questions coming in. But before we just dive into the questions, let's do a quick run around of some of the more sort of topical issues which affect us. And I'm just going to pitch this to the members of the panel, and let's have an answer or two. I'm going to ask each panel member to restrict their answer to, a one-liner, if I may, or 2 lines at most, conscious of the time that we have. So let's look at that. In terms of our quickfire session, let's look at what are the requirements for an LD clause to be enforceable in your jurisdiction. David, from England, a quick response.
So essentially just clear contractual drafting and obviously a completion date and a mechanism for extending a completion date, because liquidated damages won't work if you come up against the doctrine of prevention. Time will become at large in those circumstances. So a completion obligation, a mechanism for extending a completion obligation for things that are not at the contractor's risks, but there are no other specific requirements. All I would say is, obviously, what you then look at is the standard forms in use in any particular jurisdiction, which may introduce additional conditions precedent to the entitlement to deduct liquidated damages. And in the case of a JCT contract, which is the main domestic form in the UK, you do have to give a number of notices in order to crystallize your entitlement to deduct LADs. Yeah, that's the position under English law.
Yeah, thank you, David. Gopal, what's the position in India? And before you answer that, you'll be aware that there's a question that has already been asked relating to Section 73, and I think the two probably can be handled together.
Three lines: a clear contractual stipulation which is mutually agreed upon. B, in the light of the judgments of the Supreme Court, the need to establish actual loss or injury. And yes, the Supreme Court judgment in Kalashnath says, yes, you can use 73 and 74 together, 73 being a yardstick of reasonable compensation.
Fantastic, very concise. Thank you for that. Arun, what's your perspective from the Middle East?
I think a lot of what David said also applies here. In addition, what we tend to do is you include the words genuine pre-estimate of loss, just to give some indication, obviously, that parties accept that the rate has been agreed as a genuine pre-estimate. But more importantly, it's not just enough to use those words. I think there should be some mechanism to try and reduce LDs, particularly where, for example, there's partial takeover. And also, I think the way the rates are calculated needs to be looked into. In my experience, often it's just a percentage of the price, as you said earlier, Adrian, 10 to 15%. But if there's a bit more scientific analysis of that number, that reduces the risk of the court just discarding that number altogether.
Yeah, well, thank you. And I'll just add to that, which is it's got to be good practice for the parties to retain the documentation which shows how they arrived at their delay damages, so that they can present it to a tribunal or to the court if necessary, to show that it was a genuine pre-estimate, it had been calculated, it is based upon something sensible. There's an English case which went through a TCC, Technical and Construction Court, in 2005, I think it was, which basically the court upheld the liquidated damages, which had been pre-estimated at £45,000 per week, even though at the hearing it was proven that the actual loss was £25,000 or so. And that's because the court took the view that it was a genuine pre-estimate, the necessary documentation was provided, and therefore it was proven to be a genuine pre-estimate. So the court had no reason to consider it to be a penalty, even though the amount was in excess of the actual loss incurred. Now, of course, we've heard from Arun that that position might be open to challenge under the laws of the UAE. But that just goes to show how it is important to retain the necessary evidence.
Adrian, can I just make one quick point on that case and your point, which is, you know, under English law, that could have been zero. That's the point. You know, there's no requirement to show that any loss has actually been suffered, and that's one of the fundamental differences, I think, between the English common law position and much of what we've been hearing from these other jurisdictions, of course, most notably India. But yeah, in that case, the employer's loss could have been zero, and the LADs would have still been enforced at £45,000 per week.
Absolutely. And I think it goes to show how fact specific all of these cases are. Now, we've answered Mr. Malini's question, I hope, and we've had another question about the types of matters to which liquidated damages apply to. Please do feel free, members of the audience, to ask your questions, put them inside the chat box, and they will find their way to us. But whilst we're waiting for those to come through, we've heard from David about whether LDs apply after termination, and he's very clearly explained the position in English law and how we've had a triple point case in the Supreme Court. What is the position, Arun, in the UAE relating to LDs applying after termination? Do you have a view on that?
Yeah, I think it's the orthodox position, which is it tends to terminate with the contract because it's viewed as a secondary obligation, unless, of course, you've expressly stated it to be one of the surviving clauses post-termination. And if you do that, then it needs to be carefully drafted almost akin to an independent agreement granting damages in the event of contract termination. And there's been at least one case I'm aware of where the court did apply an LD's clause that is expressly stated to survive termination. Of course, with the caveat that there's no binding precedent, but at least it could be persuasive.
Yeah, thank you. And Rohit, what's your perspective on LDs applying after termination?
So I think, Adrian, from an Indian law perspective, or from an Indian, what I see based on my experience of Indian contractors and employers, it's a very kind of a confusing situation. Things are not very clear with the triple point technology case coming in. How the Indian courts are going to view that's also not clear. But yes, unless Mr. Gopal Jain comes up with an alternative view, I have not seen any judgment related to this in the Supreme Court or the High Courts. But what tribunals have been doing is they have been following the orthodox position, as Arun said, that levy liquidated damages until the contract is terminated, and beyond that go for the actual loss.
Yeah, thanks, Rohit. Gopal, what's your view?
Well, I think this is one for the courts. I think this fallback position would be the conventional one, that the life of the clause comes to an end upon termination unless expressly it survives like an arbitration clause. But this is not an independent clause. So perhaps the English judgment will be cited in an arbitration or an Indian court proceeding, and the court will bring some sense of finality to it. But exactly as Rohit said, one can't put a finger and answer it, but one can second guess as a default position, that is the conventional position, that it's coterminous with the life of the contract.
Yeah, thank you for that. I mean, another area which is of interest is liquidated damages were described by David as providing some certainty to the parties. That certainty potentially fails if the liquidated damage clause fails. So the question then arises as to whether the liquidated damages figure, the amount that was assessed in the contract, or stated in the contract, I should say, whether it acts as a cap to actual loss. In other words, the liquidated damages claims fail, but does the amount that the parties agreed upon act as a cap to its actual losses? Arun, what's your perspective from the Middle East on that?
I think the answer is it might not, simply because if the LD's clause itself is not being applied, it's presumably because the court or the tribunal views it as not commensurate with actual laws. And therefore, but in my experience, as I said, it's usually a reduction. So the cap in that sense does put a bit of a ceiling. But nonetheless, I would say they view it quite differently. So general damages, I wouldn't necessarily say the LD's cap is the cap on general damages.
No, but I guess UAE's system and systems generally want to try and understand and interpret what the parties had intended by their deal. So it may well be that that would be a component to take into account. Sorry, Arun, please.
No, I was saying, yeah, I agree. It's ultimately subject to the facts, but yeah, agreed.
Absolutely. Gopal, what about in India?
Well, first things first, as both of you said, it will depend on the clause and the intent of the parties. But broadly, it will act as a cap, as an outer limit. And that's David's point, and that's fundamental of having some kind of commercial certainty, as I call it, upfront at the time of formation of the contract itself. That would be really the position, unless some new innovative interpretation comes from our tribunal or the court.
Thank you. And Rohit, do you have a view on this?
I think it's more of a legal question, so I'll leave it to the legal people to reply.
Okay. Well, conscious that we're heading towards the end of our time allocation, and just in case any further questions come through, let's just rest upon a final point for us to consider, and which is whether liquidated damages are a good thing or a bad thing, and in particular, are they good for lawyers and bad for experts? Rohit, what's your view on that?
Yeah, of course. I would say from an export perspective, they are good because only if when LDs are levied, then we get business to prove that well their LDs are to be levied or not to be levied. But from a general construction perspective, I think LDs should be there and have to be there because they act as a deterrent. But an unethical or an illegal usage of the LD clause should be avoided, and it should not be used, in case there is a genuine entitlement for the contractor to get an extension of time.
Thank you, Arun. What's your take on that? Good or bad?
I think it's definitely good for the parties generally. Some sense of certainty of what you're looking for. Somewhat selfishly, both for experts and lawyers, it gives you a figure to either try and overturn or succeed on, which is not necessarily the best way, but it's something. But ultimately, I think it's something that is there as a deterrent, as Rohit said, and lawyers come into the picture both before and after, which is why I think it's definitely good for lawyers, because in our experience, employers can be somewhat trigger happy, but we need to guide them in the process, and they often are receptive when we highlight the risks.
Absolutely. And Gopal, your view?
I call it win, win, and win. Win for lawyers and experts, win for parties for certainty, and win for our Indian courts. From 1960s to 2018, you had a slew of judgments, so it's kept them constantly engaged and evolving. But to digress for just 1 second, we now have a concept in India called Atmanirbhar Bharat, that is self-reliant India. And I think time has come that our Contract Act, which dates back to 1872, and some of these provisions which date back, we really need a more modern clause which brings in the real certainty, because today we've seen interplay of contract and court rulings, and that's not necessarily good from a certainty point of view. So based on all these principles, it's time to embody within the codified law a more modern and fairly balanced provision on this, with all the rich learnings from cases, as in judicial cases, and from projects. And they vary from project to project. So uniformity of such provisions across the contracting models in India will also add to certainty. And I think for business, in the risk-reward matrix, certainty is very important to reduce risk. So I think that will sort of end court interference, and parties will know what they bargained for, and that's what they'll get. So I think that's really the takeaway.
No, thank you for that. Very wise words. David, what's your perspective from England?
I think liquidated damages are fundamental in the context of time in construction and engineering infrastructure contracts, for many of the reasons that you yourself elucidated upon, Adrian, the sort of absence of requirement to prove the quantum side of general damages around time, and all the kind of economic and policy reasons that I referred to in my original remarks. But I want to make one other point, which is, whatever the differences across our different jurisdictions as to how the law approaches the interpretation of liquidated damages provisions and indeed the enforceability of them, let's just say that one way or another, we get to an expectation that the legal systems in our different jurisdictions do provide for liquidated damages to be enforced as a matter of law. That's a very different thing to the parties, and in particular clients who might otherwise be benefiting from liquidated damages, deciding that the right thing to do is to contracharge their full liquidated damages entitlement. And if you look at what we've all just come through over the last 2 years in terms of the impact of the global pandemic on construction projects, I've had many experiences where I've given detailed advice on the contractual rights of my client, and then I've metaphorically pushed the contract away on the table, and I've said, now let's have a sensible commercial discussion around where the best interests of our position lie in this project around the issues that we're facing and dealing with. And in the UK context, it's worth saying that in many instances, clients who have accrued significant liquidated damages entitlement ultimately do not offset that full entitlement against sums otherwise owing to their contractor. They may well have a more intelligent, nuanced, commercially informed discussion or negotiation process in which their position is supported by their liquidated damages entitlement. But for example, they might be dealing with, a disputed variation account or loss and expense associated with disruption effects and so forth. And, whilst the LADs play a really important role in that process at that final account stage, it isn't automatically and mindlessly the case that people seek to leverage their full entitlement all the time. And I think that point is worth making because there's a wider commercial context that needs to be acknowledged here. But yes, they are of benefit to both parties. Of course, they generate work for lawyers and experts because unfortunately, that's just how it is in our industry, I suspect.
No, absolutely. And just picking up on a couple of those points and the point that Gopal made, I mean, liquidated damages need to be respected by the legal systems in which we all operate because they reflect the intentions of the parties. And of course, whilst there needs to be some degree of policing of these provisions to ensure that fairness prevails, one does wonder whether it's appropriate for courts or indeed tribunals to undermine what the common intention of the parties was, whatever it was they were intending to do. So liquidated damages clearly do have an important role to play in the construction contracts we all deal with on a daily basis. So without
and it still remains an enigma. We started with an enigma and ended with an enigma.
I think you're absolutely right, and it shows that what an interesting area it is. But it's one which I think there's an amazing amount of commonality between the jurisdictions that we've been dealing with. And when one looks at the arbitration world generally, that commonality comes together and shows strength and provides guidance for the future. We're all at the end of our time, I'm afraid. It just remains for me to thank this excellent panel, Rohit, David, Arun, and Gopal, for your very interesting and valuable contributions. I should like to thank our audience for their questions and for participating in today's session. And I should like to thank the SCL and all of the organizers for hosting this wonderful session and such a great conference and showing leadership in the way that you are. So thank you, everybody. It's been an absolute pleasure, and I look forward to hopefully seeing you again soon. All the best now.
Thank you, Adrian. Thank you. Thank you.